I'm Tim Gephart. I'm Vice President of Claims at Minnesota Lawyers Mutual. Malpractice claims asserted against lawyers insured by MLM are increasing, both in frequency and severity. The claim statistics gathered by MLM and by the ABA indicate that on the average, each lawyer can expect to have 3 malpractice claims asserted against them during their practice career. 1 in 2 lawyers in practice now will have to deal with at least 1 claim over the next 8 years. It can take 2 to 3 years after legal services are rendered for a claim to be reported. And claim frequency is highest for lawyers who are in practice between 5 and 20 years. Some of the factors impacting the increase in frequency and severity of claims, we believe at MLM, are first of all that lawyers are practicing today in an increasingly difficult environment. The practice of law is becoming more and more complex. Consumer expectations are exceptionally high, and the courts are continually expanding the basis for liability for claims against lawyers. Increased competition is fundamentally reshaping the legal practice. One of the biggest problems that we have in looking at the claims being asserted against the lawyers MLM insures is not so much that the lawyers don't know how to practice law, but there are failures, basic failures in the lawyer-client relationship, and those failures lead to claims. The types of errors that we see lawyers committing and the types of errors that clients are complaining about that are causing claims are consistent regardless of the area of practice a lawyer is involved in. Topping the list is a failure of the lawyer to provide the client with sufficient information about their case. Clients also complain that lawyers failed to follow their instructions, that lawyers engaged in representations involving conflicts of interest, that lawyers did not know or did not properly apply the law, or that the lawyer procrastinated in the handling of their case. Malpractice problems and ethical complaints are closely related, even though the law of lawyer malpractice and the law of professional discipline has developed from different origins and for the most part has developed separately. Legal malpractice law has been developed as an aspect of the common law of tort, and professional discipline is developed as a regulatory function of the state Supreme Courts. They are differentiated by the problems they address and the interests which they serve. Legal malpractice law seeks to compensate the victims, and very little stress is placed on deterrence of the behavior that caused the problem. And under legal malpractice law, there's really no impact on a lawyer's license and his ability to practice. Professional discipline law, on the other hand, is oriented to the protection of the public. It stresses deterrence heavily, and it achieves its goals by limiting or prohibiting lawyers from practicing. Importantly, professional discipline law provides no compensation to the victims. The separation of these two strands of law governing lawyers' conduct has led some courts to rejecting tort relief based solely on an ethical violation, and this thought is reinforced by the preamble in the ABA model rules of professional responsibility. Nonetheless, it seems to fly in the face of common sense to say that the ABA model rules and your state model rules for lawyers have no bearing on the central question of a legal malpractice action. That is, whether the lawyer's conduct fell below minimum professional standards, especially in light of the relatively low threshold for relevancy. The rising incidence of malpractice claims and the rising severity of the claims begs the question of what can we do to reduce the risk of legal malpractice claims in a law firm. I believe that one of the essential things to do is to implement in your law office a well thought out program of risk management and quality assurance. Remember that lawyers can't change the environment in which they work, but they can control the circumstances in which they practice their profession. One of the ways that this can be done is by integrating the ABA model rules of professional responsibility and your state rules of professional responsibility into a risk management and quality assurance program for your law office. That program should serve to accomplish three objectives. First of all, to protect your clients. Secondly, to serve as a means to providing the highest quality of legal services possible. And thirdly, to safeguard the assets of the firm. What exactly is risk management and quality assurance? The textbook definition of risk management is that risk management is a systematic process of risk identification, risk analysis, risk treatment, and the evaluation of potential and actual risks. Risk management serves as the mechanism for risk reduction and elimination and the avoidance of economic losses. We've talked about a number of different terms here. We talked about risk management, quality assurance, loss prevention, and malpractice prevention. Essentially, these terms all mean the same thing. It's important to consider, however, the connotations of the terms when discussing this process. Negative connotations can turn people off before they actually understand the process. I believe that quality assurance has a very positive connotation, and I believe that's a good thing to call your program. Essential components to implementing law firm quality assurance programs come out of risk management and quality assurance having emerged as an operational component of the practice of law based on a number of factors. These factors include rising legal costs, greater consumer expectations, adverse claims experience, escalating verdicts in legal malpractice cases, rising insurance premiums, not only in your professional lines, but in all lines of insurance, and the lack of availability of insurance coverages. There can be some barriers to establishing a risk management or quality assurance program in the law firm. Historically, there have been these barriers, but because of the factors mentioned earlier, those barriers are now being overcome. Some of the barriers I'm referring to are, first of all, lack of commitment from management. Management might argue that implementing a program of quality assurance or risk management is too much of a time commitment for their lawyers and for the firm. They might argue it's too great of a financial commitment, and most importantly, they might fail to perceive the importance of implementing the programs. There might also be lack of a perceived problem. What we know won't hurt us. We have a good staff, they don't make mistakes. There can also be a very lax attitude on the part of management. Claims only happen to the other guy, and why should we go to all of this work when we've got insurance? If we make a mistake, our insurance policy will cover us. And lastly, there can be a fear of dealing with sensitive issues. Issues like impaired lawyers and issues like legal mismanagement of cases. There are a number of costs that are inherent in establishing a quality assurance program, and there are also barriers that we mentioned. You're going to have to overcome the barriers, and you're going to have to believe that it's worthwhile to put a program like this together and implement it in your firm. There are some costs that aren't so apparent that are associated with a loss caused by a legal malpractice claim. At first glance, the only cost perceived might be the amount of the deductible on your insurance policy. But there are other costs that are associated with losses that do occur. Most importantly, I believe, is damage to your professional reputation. How likely is it that clients are going to be referred to you if the word gets out that you've been subject to legal malpractice claim? That can lead to a loss of potential clients, and it also adds to the adverse claim experience of the group of lawyers as a whole, which could cause everybody's insurance premiums to go up. There are also costs that are associated with losses that might occur. First of all, stress levels can build up as a result of worrying about making a mistake. This can lead to less than optimum use of resources. For instance, lawyers, out of a fear of loss, might choose to limit their practice or leave their practice altogether. Society is also affected. Qualified people might choose to leave the practice of law. In view of all these costs, a quality assurance program implemented in a law firm is a bargain. There are other costs that might be incurred in implementing the program, such as consultant fees, possibly having to update forms, update computer hardware and software, and there are some other considerations. But the biggest investment will be your time and your commitment. There are some other reasons besides dollars and cents to implement a quality assurance program in the firm too. Rule 1.1 of the ABA Rules of Professional Responsibility states that a lawyer shall provide competent representation to a client. Competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. You owe it to your clients to do the best job possible for the client. The better the job you do for the client, the more informed you keep the client, the happier the client will be. The perception will be that they've gotten their money's worth from your representation, even if things don't turn out exactly as they may have expected. Remember, a satisfied client is not likely to sue a lawyer for malpractice.